those watching now. So we got a fun event today. I got a few scenarios planned. So we learn about estate administration is the topic today. So my name is, gotta click the right place. There we go. My name is Rilus Dana. I'm an attorney. I practice here in Arizona and California at Rilus Law. Technically, we're Dana and Associates. I started using the name Rilus Law just to clarify. So if you know us as Dana and Associates, that's still us. So been doing this for almost 2 decades if you count my time in law school. So here's scenario number one. So maybe you know these people, maybe you are these people, but these scenarios will help us learn about estate planning. So Mary color codes her calendar, alphabetizes her spice rack, and triple checks her email. When her father, John Johnson, suddenly passes away, she's sure he left a will. She searches his house. Here's what she finds: a shoebox labeled important legal stuff, filled with takeout menus, old lottery tickets and expired coupons, a sticky note that says draft will, maybe next week, but no will. So first question, does Mary automatically inherit the house? So what do you guys think? Does she automatically get the house? No, not automatically. So if someone dies without a will, the laws of intestacy apply. Intestacy is a word, this means no will. So we look at the laws of intestate succession, and we need to know if John was married, because if he was married, then his wife's going to be entitled, or if there's other children. Or if there's no spouses or other children, then it would go to Mary. All right, here's a twist. So what if Mary's long-lost cousin suddenly claims to be John's only heir? Then what? So depends on how he's claiming this. Does this sound realistic? We got our admin people watching in the back. This is like a lot of scenarios. Seems like a lot of things. So it depends on how John's claiming this, right? What does John have that he's claiming it? Does he have a valid will that says he's in charge? That could change it. Or is he just saying that she told him that, or he told him that? So, all right, next one. Let's move on. We'll keep them moving. Next, we got David, the helper Green. So David is the guy in the family who just takes care of things. He's the only one who always remembers mom's birthday. He organizes the family reunion and carries a multi-tool just in case. When his uncle Albert got sick, he gave David power of attorney so he could help pay bills and manage finances. Now that Albert has passed away, David is still in problem-solving mode. So here's what he's done so far. Called the utility companies to shut everything off, drafted a Craigslist ad for Albert's house, started telling people, I got this. That's my favorite one. There's just one tiny problem. Albert is dead. So here's the question. Can David use his power of attorney to sell Albert's house? We got a lot of Davids in the audience today. But, what do we think? Can David use his power of attorney? No. You're right. You're shaking your head no. Power of attorney is not valid. So who does have the authority? So someone would have to go through probate, right, to get the authority. Can multiple people claim to manage the estate? They can, and again, depends how they're claiming it. Do they have some sort of valid legal document that shows they're entitled, or are they just talking? Okay, so the teaching moment here: a power of attorney is void once someone passes away. So a power of attorney is only valid while that person is alive, the principal is alive. Only a court-appointed personal representative can act on behalf of the estate. So if the property is titled when we say the estate in this context, it means in the name of the dead person still. So if things are titled in the name of the person who's passed away, that's in the estate. That's when a personal representative has to get appointed. So how does someone get appointed as a personal representative? They file through probate. We'll see more on that. So what if Albert told everyone he wanted David to handle everything, but it was never written in a will? Yeah, shaking your head. No, yeah. So not necessarily. So unless there's anything legally valid, it doesn't really do anything. But if everyone's in agreement, if everyone's in agreement, says yeah, this is what he wanted, they could do a settlement agreement. So all the parties can get together and agree to administer it that way. And we do see that quite a bit too. Once everyone knew this is what someone wanted, but we don't have anything valid legally, so the parties agree to administer it that way. Okay, next scenario. We got Lisa, the trust believer Carter. So Lisa loves estate planning. Not in a weird way, just in a let's keep organized way. I guess it's kind of like me, huh? It's kind of like us. Her mom, Evelyn, shared this mindset and proudly told Lisa, "Don't worry, honey. I set up a trust. No probate for us." So when Evelyn passed away, Lisa wasn't stressed. She assumed everything would go smoothly. But then Lisa checked the county records and saw that her mom's house was still in Evelyn's name. So mom's house was still in mom's name individually. Lisa started sweating. Did her mom forget to move the house into this trust? Does this mean the house has to go through probate? Did she inherit a giant mess? So does the house still go through probate even though there was a trust? What do we think? Let's see, I should check on my comments too, the people watching online. So what do we think? Does the house still go through trust?
Does she have a trustee designated?
Well, the house is titled in mom's name individually. So there, even if a trustee is designated, it would still have to go through probate. Oops. Okay, so can Lisa transfer the house and the trust after her death? She's going to have to go through some steps before she can do this. So a lot of times when people do a trust, they also do it's called a pour-over will, a last will and testament with the pour-over clause that says if anything's left outside of the trust, it will be added to the trust after the fact. So she could add the house to the trust, but it would take a probate. So what mistake did Evelyn make? So she didn't fund the trust, right? Although she created a trust, for some reason or another, her house was not titled in the trust. Now, sometimes this happens. We see people, sometimes they refinance. Maybe they get a new loan on the property. And as part of that process, sometimes the house gets moved out of the trust. They don't even realize it. So that's one of the ways. Or maybe they just never put it in there to begin with. So when you have a trust, you have to make sure you title the assets into the trust. If a home's still in someone's name at death, then it's a probate asset. It's part of the estate. So how to avoid probate? You got to deed the home to the trust. And then also you got to confirm that all your other assets, your bank accounts and investments, are either in the trust or they have a beneficiary listed. Okay, the twist. So what if Evelyn had a handwritten note that said, "This house belongs in my trust"? Would that count? Maybe in California, but not in Arizona. So California, you can do a thing, it's called a Hegstead petition. If it looks like something was supposed to be in the trust and there's evidence of it, there's a way to avoid probate, but not in Arizona. So that handwritten note, it could be a valid will, meaning saying you might have to do probate to validate that will and activate it, but just that writing wouldn't get it into the trust without probate. So you got to make sure you fund the trust. Okay, next one, we got the Anderson family. All these are purely made up. So the Anderson siblings were mostly normal growing up. Sure, there were some big Thanksgiving arguments, but nothing that scarred them for life until their dad, John Anderson, passed away without a will. Now they need to pick a personal representative to handle the estate. Alice, the oldest, is the natural leader. Michael is okay with Alice running things. Sarah doesn't care as long as she gets her share. Sounds nice, right? Nice rhyme to that one. Mark is just being difficult. Mark refuses to sign the paperwork. I don't trust Alice. She always took the best Halloween candy when we were kids. I want to be the PR. We've seen probably crazier stuff, haven't we? That's why this is so believable. So people hold on to stuff forever. The other thing I say too is people mourn differently. After someone passes away, it often brings out the worst in people. So they're not always acting rationally. All right. So if Mark refuses to agree, can Alice still be appointed as the PR? Well, what happens if they don't agree? So if they're not in agreement, they're going to have to do what's called a formal probate. So informal probate is when everyone agrees. So if everyone's in agreement of who's going to be in charge to administer the estate, then we can file an informal probate. In this situation where we have Mark who's holding out and not in agreement, then informal probate is not an option. So we would have to file a formal probate. So the other three kids could say, we want Alice to do it. And then what happens is they would schedule a hearing. And then Mark would have his chance to object. So he could show up to this hearing and say, no, I object. I want to be the PR, and give his reasons why. And just good old fashioned litigation. They can fight it out and let the court decide. Now, what often happens, now a lot of times people complain, but are they actually willing to follow that up in writing? So a lot of times with formal probate, we'll have the hearing, and the person that's complaining will not even show up to the hearing. So let's keep going again. So the twist. So what if Mark never responds to the probate petition? Can Alice move forward without him? So this is what happens a lot. So if they file the formal probate, and Mark maybe calling her and texting her this and that, saying horrible things, but if he never shows up to the hearing, never formally objects, the court is likely to appoint Alice if everyone else is in agreement. Now, for someone to object to a formal probate, they have to they got to show up to that hearing, and then after that, they have to file in writing. So it does take some work and some money. They have to pay the filing fees to object. So if they have a real reason, they could, but oftentimes, if they're just upset about the Halloween candy or some trivial issue, a lot of times too, it seems like someone's just trying to drag it out. What can I do to stall this? They need me to sign this, so I'm not going to do it. So that's the other reason we like doing the formal probate. If someone's trying to take that approach, we can just get things moving, schedule the hearing, and that's it. If they don't show up, it's moving. Okay. All right. Technical difficulties. Okay. This is our last scenario, and then I'll open it up for some questions. So if you're watching on the live, you can put your questions in the comment, and I'll try to get to them. Or the people in the audience, if you have questions, I can go over those. Oops. I have to keep not driving very good on here. Okay. Here we go. We got Tom, the reluctant trustee Reynolds. This is our last scenario of the day. Tom's the oldest sibling and has always been the responsible one. But now that his dad Robert has passed away, Tom is taking avoidance to a whole new level. His siblings keep calling him. The bank is sending letters, and their dad's house needs repairs. But Tom, he's busy, aka watching YouTube videos on how to build the perfect backyard pizza oven. Problem? Tom is a successor trustee of his dad's trust. The family can't access bank accounts or sell the house until he acts. His siblings are getting frustrated and threatening to hire a lawyer. So here's the question. Can Tom just start handling things, or does he need to take official steps? What happens if he never accepts his role? And why does he need a new EIN? So can he just handle things? He does have to take some official steps. He's got to accept his duty as the trustee. So just because he's named in there as a successor, he's got to step up and show that he's actually acting as the trustee. So I like to say you got to prove it to the bank. When you go to the bank and you show them the trust, you got to connect the dots. Show them that dad's passed away, you're the successor, and that you've agreed to take on that role. And then they're also going to need a new tax ID number for the trust. So the trust was using dad's social while he was alive, but after he's gone, it needs a new tax ID number to record any income earned from that time. Can Tom be removed as trustee? What do you think? Can he be removed if he doesn't do anything? Yeah, he can. Can he be held personally liable? Yeah, he can. So trustees must act. So they have to accept the role and sign a form that indicates that, get an EIN, a new tax ID number, and then start following what the trust says. If they refuse, ultimately the siblings could take him to court, and they would probably be successful. So, and he could be personally liable. So we do see that a lot, and sometimes, like if we've represented the trustee or the people, maybe the trustee comes to us, and then they don't do anything. They hire us and they don't do anything. We've had that happen before, so we end up where we fire them as a client, saying that you got to fulfill your duties, and then the beneficiaries will start calling us. Hey, what do we do? And we have to explain that we have a conflict of interest. We can't tell those beneficiaries anything because we still owe a duty to that trustee. And but we explain to our client that if he doesn't do anything, that he could be liable. All right, so that's it for the presentations. I want to point out some of our free resources online. riluslaw.com. I have lots of good stuff for you there. We've got an AI bot there, can answer your questions. A free last will and testament, and some other good forms there. Let's see, we got some questions online from Michael. How long can a formal probate take from start to finish typically? So it could take forever. They could fight every step of the process and take years and years, 3 years. Once we have that first hearing, so once we file for the formal probate, depending on the county, they give us the hearing, what is it, Lori, about 2 or 3 months out usually. And then if they don't show up or object, we can get the person appointed at that hearing. And then it's the regular probate time, which is we start the 4-month creditor period. And then as soon as they collect all the assets, they can close it. But sometimes they fight every step of the way. So it can be years and years.
Are there time limits set on any of that process?
Time limits is
time limits. If the trustee doesn't act within a certain time frame, when is that time frame? And then
good question. Good question. Most trusts, it usually says like as soon as reasonable and practical, the trustee must distribute, and that's kind of that fine line with our that Reynolds guy in the pizza ovens, that wasn't acting. He's there's not a magic number, right? It's not like you have to do it within a week or a month or 6 months. It's just it depends on the type of assets in the trust, right? And but it's pretty obvious in the last scenario that he wasn't acting at all. But if a trustee if they get appointed and they're going through the motions, like we have some probates that have been open forever, right? It seems like it, but because they have hard assets. We have some where they have lots of real estate, undeveloped real estate, and it's hard to find a buyer to recognize the value of it. So we have to keep it open until we can find someone that can solve that problem. Did that answer your question?
Yes.
Okay. All right, we got one online. Can you discuss taxes? My mom passed away in June, and I'm the trustee. I will file her taxes for 2024. Well, will I also have to file taxes in 2025 since I'm just now listing and selling her house? All right, Karen, here's my answer. Check with your tax advisor. No, I know enough where I can help you. Um, so as far as your mom's personal taxes, if she had to file before she passed away, she would still have to file. Now, from the time that she passed away, it depends on how much income was earned by the trust. So you're listing and selling her house, unless that house was rented and generating income, um, or if she had other assets in the trust that are generating income that could cause the need to file taxes. But my official answer: check with your tax advisor. Let's see. Another one from Karen. What forms does a trust need to provide the beneficiaries for the year that they get a distribution? So maybe some of the tax forms, depending on how you do it. But before we send anything to a beneficiary, when we're representing the trustee, we like to send a distribution schedule that discloses everything, discloses the legal fees, the trustee fees, all the expenses, and then the proposed amount that the beneficiary is going to get. So and then we ask the beneficiary to sign a waiver and release that they agree to all those numbers in there. So I would recommend doing all of that before you send anything out. And then Karen, if you haven't found our trustee toolkit, I would look for that on our website, riluslaw.com. The trustee toolkit has some of those resources. See, Andy, if a trust appoints successor trustee, will they work on the assets in the trust? If trust appoints successor, I think so. I'm not sure exactly what you're asking there, Andy, but the successor trustee manages the assets in the trust after the original trustee resigns. So usually the person that creates the trust acts as the trustee themselves, as long as they're alive and healthy. And then after they pass away, the successor trustee gets appointed, and then they manage the assets that are in the trust. Yes, sir.
You had mentioned a case in which the house was in a person's name. So if it wasn't in the trust and the house exists, then if they have other documents such as life insurance or anything else, do those documents, because they set a beneficiary, does that work the same? And can you use that document and say, well, obviously because this person wanted me to be the beneficiary of this, do I then become the trustee or the?
So you go asset by asset. So life insurance. Okay. So if the life insurance named beneficiaries, that will be distributed according to what that said. Okay. And then if there's something with no beneficiaries still in the name of the deceased, that's in the estate, we say. So if something's in the name of the estate, we pull out the last will and testament if there is one. Or if there's not, then we look at those default intestacy rules. So we go asset by asset. So everything. So now a lot of times we have a little bit of everything, right? We have some things that have beneficiary designations, and maybe there's a trust with some things in it, and then maybe some assets not in the trust. So we end up having to do, and if there's a pour over will, we end up having to do a probate to activate the will, collect the assets, and then we collect them and put them in the estate. And then from the estate, they end up going into the trust. So, are any other questions?
One more.
Yes.
What if the asset is not listed anywhere? Mom happened to buy a new house, or a second house, anything, and that is not listed in any of them. What do they do from there?
Good question. So the question: what if the asset's not listed and they don't know about it? Right. Then nothing, I guess. Right. Sometimes people call us years later. It's not uncommon. People call us years later. We just discovered this. We had one the other day where they discovered from 2016. Their mother passed away recently, about a year or so ago, and they were able to collect everything. But I guess they found an old account from when she retired. One of her old accounts was never sent to her, so it was in unclaimed property. So a big part of or the solution to that, I would say, when you're planning your estate, you want to leave good details. So when we do our estate plans, we're talking about how to leave clues for your successor trustees to make sure they're not going through that process of trying to figure out what someone has. We want to make it easy. So good question. That's a good point. So, oops. All right. So okay, so our next event. So I'm enjoying doing these, and I'm trying to build some momentum of both the in person and the online. So next month is going to be more estate planning focused. Same kind of style. We're gonna make it fun, and we might learn something too. This is saying invite your friends that are into real estate, taxes, financial planning. Good information for all of them. And here's my best deal for you guys showing up, and you guys that are still watching here. We got 15% off estate planning packages. So to get this deal, just mention it when you book your consultation, and it's good until April 1st. So why work with us? So experienced attorneys, flat fees, modern approach, real results. Thank you guys. Let me end this here. And there we